Hi, everyone, and welcome to today's webinar. Can your global supply chain keep a trade secret? Brought to you by IFAI's Advanced Textile Product Division. My name is Amit Kapoor, and I'm the president of First Line Technology and the vice chair of the ATP division. The Advanced Textile Product Division represents a safety, medical, and interactive textile product marketplace. ATP also offers sponsored scholarships to support the future of the industry. ATP provides a forum to exchange information like today, solve common problems, and develop a mutually beneficial relationship. ATP's webinar program is provided free to all industry professionals in order to grow the industry and share knowledge. Today, before we get started, I'd like to go over a few items so you know how to participate in today's event. You will have the opportunity to submit text questions to today's presenters. Everybody's on mute. You can type your questions in the questions box on the control panel. You might have to hit the drop-down arrow where you can type your question in there. After the presentation, we will collect all the questions throughout, and then we will start answering at the end of the session through a Q&A. The recording of the webinar and the PowerPoint will be made available after today's presentation. I'd like to introduce everybody today to our presenters, Marissa Frederick and Clara Jimenez from Finnegan LLP. Marissa is a partner with focuses on client counseling, opinion work, and patent and other intellectual property litigation. Clara is an associate, and her practice encompasses patent prosecution, client counseling, post-grant practice, and patent litigation. If everybody can welcome Marissa and Clara today. You guys can kick it off.
Great, thank you, Amit, for that introduction. Hello, everyone. My name is Clara Jimenez, and as Amit mentioned, I am an associate with the law firm of Finnegan and Henderson. I work quite closely with clients in the chemical industry that are trying to identify the best way to protect their ideas, protect their valuable IP, and also just develop strategies that can help them advance their business model and make their IP work for them. We are delighted to be partnering with IFAI today, and in particular with the Advanced Textiles Products chapter. We understand that the way this business is moving is quite fast-paced. There is a need for innovation to happen rapidly, and the goal of today's webinar is to introduce you to some of those forms of IP, and throughout the program we will be closing in and focusing more on trade secrets. And trade secrets, what they can mean for your business, when they can be kept, and just in general, good practices as you encounter your business relationships in advancing the growth of your companies. And then also, if we could go to the first slide, we can take a look at the agenda for today. We will begin by giving you a broad overview of the types of IP protection that are available in the United States. We will then take a closer look at the differences between protection via patent and trade secret. We'll continue looking in more detail on the management of trade secrets in technical collaborations. And this will encompass working with the different business partners that growing companies come across as they evolve. We will then look more closely through examples and practices based on our experience that can be put into place to protect your trade secrets. So let's just start by looking at generally the types of IP protection that are available. If we can go to our next slide. Generally speaking, we can look at four major types of IP protection: patents, trademarks, trade secrets, and copyrights. They offer protection for different types of intellectual property that are generated within a company. They are aimed to give value in different areas, and in that context, then they have different requirements that are needed to obtain protection, and also different ways to get enforcement when the rights are at danger of being misappropriated or infringed. Generally speaking, and we'll go in detail of more example of what each of these categories are, But if we can go to the next slide, the key difference between trade secrets and other protections like patents, copyright, and trademarks are based on the idea that trade secrets keep the protection or keep protection in the information, as the name indicates, when the owner of that information takes the measures that are needed to keep that information away from the public. In other words, the value that is derived from that information arises in large part to the fact that that information is not available and out there for public consumption, but rather kept very protected and then used to advance the particular business or the particular idea. In contrast, then we have the forms of protection where the owner of the IP gets somewhat exclusionary rights in exchange for making that information available to the public. This then gives the owner of the IP the ability to provide licenses or in some other ways monetize, if he wants to or she wants to, the value of the IP in exchange for essentially permission to have that IP used in other contexts. And typically then these are represented by patents, copyrights, and trademarks. Going into the next slide, we can take a look at what types of protection are available. And we call it an IP cheat sheet because obviously this is just a very general overview, and there is more information that can be encompassed in each of these categories. But as an introduction, it provides a good view. So in the first two bullet points, we have utility patents and design patents. Utility patents tend to protect really inventions and methods of doing things differently in a new and non-obvious manner. Typically, these are ideas in the industry. We are thinking about new innovative materials, innovative compositions, but also perhaps materials that are now suited with a new functionality for transmission of data or to display specific properties. Utility patents are pursued and filed through the United States Patent Office and require a certain level of disclosure of the detail of the invention in exchange for protection for a set of claims. In contrast, we also have design patents that are directed to protecting ornamental designs that are non-functional. Typically, is design patents can provide a period of exclusivity where the company can recoup the cost that it has invested in developing a particular design. In most recent years, the use of design patents to protect iPhones and electronic phones and other electronic devices that are coming into homes with a particular aesthetic feature has made design patents a lot more popular and used by different companies. Generally, they are less burdensome in a way to prosecute than utility patents, so they're quite attractive when the goal is to get protection in a speedy manner from the patent office. Moving on, we go to trademarks and copyrights. Trademarks and copyrights tend to protect words or symbols that are used to designate the origin of the product for trademarks, and we are talking about logos and names and slogans. And copyrights protect more writings, illustrations, works of authorship. One common misconception is that copyright and trademark protection are not as valuable for companies that are dealing with new and advanced products and perhaps even products in the chemical area, because it's not the main goal of the business to develop written products or printed products or publicity per se. However, it is important to remember that no single right can provide the protection to all the scopes of ideas and content that are generated and valuable to a company. Therefore, it's better to just think about different layers and different parts of your products and your commercial lines that might be protectable. particularly in the area of textiles, aesthetics, the way that things look, the designs that are implemented can be as important or not more important than the chemistry behind the material and perhaps the circuitry that is implemented to an innovative material. And going into the last layer of protection, and the one most pertinent for today, is trade secrets. And trade secrets can really protect really any form of information, broadly speaking, that can be kept secret, so long as there is difficulty doing reverse engineering of the product. If there is something that I can purchase a product, look at it, and figure out how it was made, that information may not qualify as trade secret because it's out there in the public. And we'll go into trade secret requirements in a bit more detail. Unlike the other forms of IP that we just discussed, trade secret is, in a way, created by the owner of the IP without needing approval or grant or registration by another entity. So it makes it fairly appealing because it can be implemented by a company's inside a strategy and inside measures without getting into exchanges with other governmental agencies. The Coca-Cola model tends to be one that is used to exemplify the different ways in which a company can take advantage of IP protection to maximize its presence in the market and its business desirability. The recipe, as everyone knows, the recipe of the Coca-Cola beverage itself is a well-kept trade secret. Is kept under guard with high security measures and has therefore allowed Coca-Cola to keep protection of that formula for as long as it is able to maintain the formula secret. The trademark of the name and the trademark of a number of the slogans that are used in its publicity are also registered and protected. The bottle itself, the design of the shape, was protected through 2 design patents early on, and over time, the shape of the bottle itself became associated so closely with the brand that Coca-Cola was also able to get trade dress protection, which is a part of or a kind of trademark protection that then provides an additional layer that keeps that design safe. Coca-Cola is also very well known for engaging public figures for its advertisement and therefore deals with public person rights and other forms of protecting that IP. Moving on into our next slide, we then enter into the question of what kind of IP should I pursue for my company. Time is limited, budgets are limited, resources are limited. And therefore, the answer really depends on what are the needs of your company. The first step, typically, based on what we just discussed, is identifying whether the product or the process that are at issue can be easily detected by the public and reverse engineer. If the answer is yes, then perhaps the best way is to go through a route of protection where some exclusivity is gained from exchanging the information with the public. So we would be talking patent protection would be appropriate. On the other hand, if the product or the process would be very hard to reverse engineer for the public, then perhaps it's suitable to keep trade secret, that information as trade secret, because the immediate cost of doing so would be relatively reduced. It would just require implementation of internal policies, and it would provide almost an immediate protection for as long as that information is kept secret, that protection can be in place. Continuing on, the next questions go on timing and really dealing when is protection needed. I think I have the opportunity to work closely with small and medium-sized businesses, and I often get questions on people that want to be able to really make business decisions, understanding the kind of protection they have. They have a product that is in the development process and about to launch, or they want to disclose the information they're working on to potential investors or potential partners and don't want to risk losing that valuable information. At the same time, they're going through the patent protection route, and it takes time. It takes time. Sometimes it's between filing an application and actually obtaining patent protection. It can be a cumbersome process in some areas. Therefore, if immediate protection is needed, looking into a strategy like a design patent application, if that is something that is appropriate, it's definitely worth going through that process of selecting the best form of protection that is available. Something that we don't really get in detail in this presentation today, but that it is a concern in my experience for small businesses, is the ability to protect their rights not only in the United States, but outside of the United States when they start working with suppliers or partners in manufacturing in other countries. That timing provision and definitely the scope of protection that is desired in the international space has to be a consideration in picking the right type of protection that is wanted. In this slide here, we have a closer look at patents and trade secrets. And for purposes of this presentation from here on, we're primarily going to be focusing on patents, utility patents that are primarily protecting processes, machines, compositions. Those are the ones that we encounter most often in making the decision of patent versus trade secret. And some of the key differences between the two are listed in this slide. I'm not going to go through all of them, but I will focus on the ones that tend to raise more questions in my experience. The enforcement of the patents and the trade secrets can be difficult and different. The biggest difference, I think, sometimes for people to understand between the two is that infringing, if somebody is using the patented invention without permission, it's really irrelevant what the thought process was of the alleged infringer at the time. In other words, if you're using a method that is patented, or if you are making a product that is patented without authorization, infringement can be found. In misappropriation, then there is an additional level of inquiry that is needed to establish misappropriation because there is an intent component to it. And Marisa will probably go into more detail as she discusses her experience in trade secret litigation, but it really goes to how was the information obtained. There is a lot of what was the intent when the information was taken and how the information was eventually used. Other differences involve, as we discussed before, trade secrets are attained through private efforts, and there are no costs or of registration or application with a governmental entity, and the protection is almost immediate versus what is obtained or how long someone must wait to get patent protection. Another advantage that is quite appealing for people, as we saw with the Coca-Cola bottle, the Coca-Cola recipe, is that through trade secret, the protection can be indefinite. In the other hand, we have a patent protection offers a 20-year period of protection since the time of filing, which means that at the time that the patent expires, the invention is out there and is free for the public to use, and that is one of the less appealing, if you will, notions for some of the people that are deciding between these two forms of protection. We can move into the next slide. And we are talking now, why should you care? Why is this particularly relevant to new technologies or technologies that are moving at the fast pace that the advanced textile industry is moving? There are many players. There are many players involved in making a product and making a product be suitable for market, making prototypes, getting funding. And one of the issues that we often see in our experience dealing either with creating the layers of protection needed, but also in the enforcement, is that sometimes the risks are not identified in a timely basis. And part of the educational process is to help business owners, to help people that are running their companies identify potential risks as early as possible so that corrective action or the necessary action can be implemented. And we list here some of the most common situations that we will illustrate through cases that have actually happened, where there might be potential trade secret misappropriation in supply and distribution chains, when seeking strategic partners for joint ventures, and in the license or licensee scenario. And we can move into the next slide. So the first example is one really of a strategic partner. The case here dealt with a jewelry designer, David Yurman, who was seeking for a partner to manufacture samples of its famous ring. And it met somebody at a trade show and began the relationship back and forth, asking this potential partner to create a prototype. The relationship eventually went sour, and it went sour when at the next trade show it was discovered that the failed business partner had now started selling a replica of the ring that had protection. Through this process of trying to get the prototypes and the samples, there was an exchange of information, including highly confidential drawings, highly confidential material specs. The case eventually settled, but it definitely took an impact on both parties trying to figure out how that could have been prevented. And with the strategic partners, understanding the level of disclosure that is being made, keeping the information that is being disclosed to what is needed to develop the particular project here was quite important. A fact to highlight in this particular case is that the amount of detail that the strategic partner was requesting from the trade secret owner was more information that he had experienced a potential manufacturer requesting in the past. The level of detail that was required of the drawings and specs was high, and if that had been identified at that time as a potential issue, it could have helped. It could have helped just raise a flag as something that could be potentially problematic. And if we can move into the next slide. And in this slide now, we have an example of a relationship that had been ongoing for a few years and then went sour. We had the owner of the trade secret here had this formula to make a very specific and particular fig jam, and the trade secret was misappropriated by the manufacturer by the manufacturer and the distributor of the company at issue here. The company was successful in actually filing a misappropriation of trade secret action and prevailing on it. The recipe itself was the trade secret. It had obviously been shared under confidentiality provisions at that time, and then when the relationship ended, after the Dalmatia was the company owner of the trade secret here, decided to go to a better price manufacturer and a better price distributor, then the former partners began selling a lower grade fig spread that was competing with Dalmatian, obviously at a lower price. Dalmatia was able to prevail in the action and recovered about $2 million in damages that were then trebled because the court found that the infringement, the misappropriation, encounters some egregious violation of the law. So it was really, there was a lot of bad intent behind the case. And moving on into our next example, licensor and licensee, we have a situation that is quite common in the area of new companies and new technologies. We have here a student, a grad student, who began working in research on a particular material, and as part of the research, ended up developing not just a new material per se, a new fiber, but also a machine for making it. the university decided to get a patent protection on the material itself, but the machine was kept as a trade secret. Eventually, the grad student went on to start his own company and was able to negotiate a license with the university where he could make the patented product, but also make use of the trade secret machine, which he had developed. The university continued researching a related subject and eventually was able to get a patent on the machine itself, which the owner of the startup company obviously found to be now an unauthorized disclosure of the trade secret. The court eventually found that the license that the company signed did not provide a specific protection for the trade secret itself, and the action was eventually dismissed. Again, a learning tip about really understanding what the licensing provisions are and what they require for protection of the trade secret is key to maintaining that level of protection. And after these examples of very specific situations, I will turn it over to Marisa, who will go into more detail in what companies can do to protect their trade secrets and what they need to know as they could prepare themselves to encounter a potential misappropriation problem. Marisa?
Thank you, Clara. We can go to the next slide. So why should you care? The cases that Clara discussed really highlights the reasons why innovators in the textile industry should really care about protecting their trade secrets. Based on sort of the evolution of case law in the trade secret area, it's clear that the biggest threat to a company's trade secrets is not a computer hacker like you'll see on the TV or hear in stories, but it's really a company's employees or a third party that they may be working with, like a consultant or a contractor, who has access to a company's confidential information and is willing to sell it or provide it to another employer or maybe even to a competitor. So one of the biggest teaching points I think to take away from this presentation today is that human interactions and human relationships are really the most common reason why a company's security measures are going to fail. And the biggest challenges of trade secret protection are even more prominent or maybe even apparent in a global supply chain, where there's suppliers, manufacturers, distributors, customers across multiple countries who may have access to and opportunity to steal a company's confidential information. So to make this more relevant to this topic today, or this industry that we're speaking to today, in what scenario do these weaknesses in the supply chain show up in the textile industry? Well, it could show up when, for example, a yarn designer sends their design to different knitters to determine who will be the best company to make it. Each time that designer is sending their new design to a company, it could be passing along confidential information that's not being provided with a non-disclosure agreement. Another way it could arise is very similar to the case that Clara just spoke about, when a startup company is formed as a result of research work that was done at a university. In this context, there's exchange of confidential information between the startup company and the university, and there becomes a situation as to who owns the confidential information and who can use it. So I think one case to really highlight is a big case in the trade secret area. It involves DuPont, who I'm sure you all are aware of. In that case, a DuPont employee and a co-conspirator were convicted of stealing technology for producing titanium dioxide. And of course, as you know, titanium dioxide is a chemical that's used to create really bright colors or bright white in paper and paint. So they conspired together, this DuPont employee and this other third party, to sell the technology to a company that was located out of the United States. So the exchange of confidential information and providing it or selling it to a foreign entity is common and something that companies need to be careful of and watch out for. So bringing this back to the global supply chain, each link in the chain in the global supply chain is really creating a potential leak, and it's possible that one of those leaks could lead to the loss of confidential business information that the company wishes to protect as a trade secret. We can go to the next slide. So now we're going to turn to what should you do to protect your trade secret information. What do you do, for example, when a chief operating officer informs you that an employee is leaving the company to work for a competitor and they're taking with them knowledge that they've had formed over the years, including confidential information about projects and strategies and customer lists? Well, you could tell the COO in this situation that, it's fine because this employee who's leaving has signed a confidentiality agreement. But if the company has failed to take the necessary steps to ensure the confidentiality agreement was in place and that they've actually protected that confidential information as a trade secret, the fact that you have a confidentiality agreement is just not going to make a difference. So what you really need to do is make sure as a company you have effective policies and procedures in place to ensure all company employees, are on the same page as to what the trade secrets are and how do you go about keeping them secret and protected. So to make sure we're all on the same page, I wanted to first kind of define these two terms for you. What are policies and what are procedures? Well, a trade secret policy is a set of company-wide rules for protecting trade secrets internally and when you're working with a third party. The policies should be short, they should be very clear, and should develop an understanding throughout the company that information that is generated by the company should be kept secret and confidential if it's going to be considered a trade secret. Trade secret procedures, on the other hand, are steps, actual steps the company is going to put in place to ensure its trade secrets are protected. And these procedures are specific to each area within the business. So that would include procedures about when an employee is hired, when an employee is fired, how trade secrets are going to be handled and disclosed to third parties, how an employee is going to handle the use of the computer, their company computer, or, for example, how personal cell phones can be used to exchange or send work information to others outside the company. So as the slide indicates, there's two ways to think about the policies and procedures. The offensive side looks at how you protect your trade secrets developed within your company, and the defensive side looks at how do you avoid litigation, how do you avoid acquiring or using tainted information that you never wish to have in the first place. So moving forward, we're going to talk about each of these, the offensive and the defensive positions, in a little bit more detail. We can go to the next slide. So how do you protect your trade secrets internally? So this slide really provides a nice list of things you should look to or look at when you want to protect your trade secrets. For one, you want to identify what your trade secrets are, do an audit, talk to the relevant people, and figure out what information gives that company a competitive edge and whether or not you're putting the measures in place to keep that information secret. I think the most important policy and procedure to put in place, though, is developing a mentality throughout the organization that trade secret information cannot be shared. So it's really company training and employee training is the biggest important point to take away from this slide, because multiple studies show that the biggest threat from trade secret theft comes from employees. And not understanding the rules and policies is really only part of the problem here. The main challenge lies sort of with a careless or sort of negligent attitude that can lead to mistakes. So what kind of mistakes am I referring to? So a mistake would be, for example, an R&D director who hires someone from a competitor, and the sole purpose of hiring that person is to find out what they've been working on at their former company. Or as another example, there could be a business executive, a CEO, who's looking at potential licenses that they may want to enter into, and they provide those licenses and the information that's being provided through these licensing negotiations to someone internally within the companies who's working in the same area. So those actions really could create problems that show that if they had the proper procedures and policies in place, they'd be educated enough to know not to do those things because it's creating a risk for the company. So good training is really the single and most cost-effective way to reduce the risk of information and to protect the company's trade secrets. So I have 3 tips, I think, to make the training successful. The first is you have to really make it inclusive. It should include everyone in the company, from the technical people to the marketing folks to people in logistics. It should include everyone. And what shouldn't be overlooked, or who shouldn't be overlooked, is contractors, consultants, and interns. And I think those 3 categories of people are actually the most important because they're less loyal and more likely to leave the company. So they'll have the confidential information of your company and then move elsewhere and use it. So they really need to be trained to understand that that's not acceptable and that's not what you can do. The next important point I want to make about what makes a training program effective is make it interesting. I'm not sure if any one of you fly Delta, but I fly it quite frequently. And Delta has what I think to be a very funny and interesting safety video that they play right before the plane's about to take off. And I watch it every single time because I know it's funny. And what the takeaway from that is it engages me, it draws my attention, and I remember all the safety rules that they are illustrating through that video. So when you make the training interesting for trade secret training, then it's more likely that the people will understand it and will keep it in mind when they practice their day-to-day activities. And finally, the third point I want to make about an effective training program is to make it continuous. It shouldn't be a one-time event. For example, like when an employee is first hired, they have it go through an orientation where they learn about the trade secret program and they sign an employment agreement. It shouldn't be limited to that. It should be a continuous process with a goal of developing a general mindset among the people and the employees at your company that they're the primary protector of the company's assets and confidential business information. If we can go to the next slide. So I included this slide just to show the importance of why employee in training is key to effectively protecting your trade secrets. I've seen just in the past 10 years that society has really moved into a mentality where everything is shared. I mean, you share personal details about your life on Facebook, you put your work accomplishments on LinkedIn, and people aren't generally thinking you should not share. And what this survey from 2012 shows is that that really is what most employees are thinking. So here it says 50% of the responders to this 2012 survey said they've taken information from a former employee, and 40% said they use it at their new job. 50% of respondents report emailing business documents to their personal accounts. 41% have downloaded intellectual property to personal cell phones and tablets. 37% have used cloud-based sharing for confidential information without permission. And over half don't even understand that using competitive data from a previous employer is a crime. So this really shows why you really need to generate or develop a mentality at your company that information shouldn't be shared and that you can't use it to sell it to a competitor or use it at the next company that you go to. We can go to the next slide. I wanted to highlight a particularly weak point sort of in the global chain. This has to do more, though, with working at the company and then what you do when employees leave. And one of the most important points is making sure that when employees leave, they understand what their obligations are to a company. There's been many situations, especially in the technical area, where you have scientists who started in college or started right after they got their PhD and would stay at a company for 20, 30 years. And then they leave and want to work as a consultant, helping other companies in a similar area with the information that they've developed over the years, all the knowledge that they have. So you really want to make sure in that situation that they understand what their rights are to the company. So whenever there's an employee leaving, you want to revisit their employment agreement and make sure they understand what their obligations are and that they still need to protect the confidentiality of the information that they have learned through the course of the year. You also need to make sure there's documentation. They should affirmatively agree and that they will keep confidential information that they've learned through their former work, and they will not use it in a new job. You should also have an attorney involved to make sure that all the legal requirements are met in terms of protecting that confidential information when an important employee leaves. One thing that often happens when an employee leaves is they start downloading information from their work computer onto thumb drives. And that's something that can easily be monitored by IT internally within the company, but that shows that it's likely that they plan to use that information when they go to their next employer. So be mindful of that and watch for it. And then to the extent that the employee is moving into a position that's very similar to the one that they had at your company, it may be prudent to contact a new employer to make sure they are aware of what their new employee's confidentiality obligations are to its former company, to make sure everyone's on the same page. We can go to the next slide. Now we're going to move to the defensive side of policies and procedures. And essentially, I like to think about this as how do you avoid a new lawsuit or avoid a lawsuit at all. So receiving third-party information really creates problems. What happens if a joint venture goes sour and all the third parties' confidential information must be given back? And what happens if you don't do that? Having someone else's confidential information without authorization really puts you at risk for a lawsuit. And so incoming information, as this slide shows, can come from a variety of different sources. It can come from a new employee being hired into an area where he or she may have worked on in a former employee. A yarn supplier or knitter could have collaborated to create a new novel fabric, and the fabric designer sends off the novel fabric design with no non-disclosure agreement. So again, it's important to look at all avenues in which information can come in and ensure that you have the proper procedures in place to ensure that nothing is received that is not either covered under a non-disclosure agreement or there's some agreement as to the fact that you can use that information. So what procedures should you have in place? Well, again, it really goes back to employee training. Any incoming employee should be aware that the company doesn't wish to receive another company's proprietary information. And if you're in a collaboration, you should really ensure that the trade secrets are identified in writing and receipt is covered by a non-disclosure agreement. I think it's also important to really restrict the use of the information and restrict the parties or the employees who can see it. So you can restrict it to only the people who have a legitimate need in seeing the information. You can also restrict the time for which you actually share this confidential information. The more you try to keep it secret, the more it shows that you're not trying to use it in a way that could be found to be inappropriate. We can go to the next slide. So again, as I mentioned, on the defensive side, really the goal is to avoid litigation. So when you're hiring an employee, this slide is really directed at employee intake. You want to make sure that you sort of checked all the areas where you could potentially make the company vulnerable to receiving confidential information. So you want to perform an employee background check to make sure everything's on the up and up. You may want to consider reviewing the employment agreements that the former employee had with its former employer, or your new employee had with its former employer, to ensure that everything is complied with and that you understand all of their obligations to its former company. Any new employment agreements that you should have every new employee sign should specifically and explicitly prohibit them from using or bringing any proprietary information of their former employer to the new company. And you should make sure you explain your company's policies and procedures to ensure that they understand they have to respect not only the trade secret policies of the company, but the trade secret policies of their former companies. And I think particular concern should be around the issue of when you're hiring someone from a competitor. That's always an area very sensitive to both the former employee and the new employer, because there's necessarily going to be information that the new employee will have that is bringing with them from their former company. And so you may want to consider having that new employee go to an area or technology area, for example, that's quite different than what they're working on with their former employer. And then really to make sure that you avoid a lawsuit, you want to make sure if there are any inquiries from the former employer that you respond to them in a manner that shows that you're trying to be on the up and up and to abide by the obligations that the new employee may have with its former employer. You can go to the next slide. So the takeaway points, I think, that's key to really carry away from this presentation today is first, you want to think about when you're developing technology in the textile area, you want to assess whether you want to pursue trade secret or patent protection. Again, it's an inquiry that's very fact-specific and really depends on the nature of the information and how you think that you want to use it. Second, you want to make sure you preserve and protect your trade secret status if you want to pursue the trade secret route. And finally, you want to avoid buying a lawsuit. You don't want to get information that's another trade secret without having the proper confidentiality measures or agreements in place. And now I think that we can turn to some questions if there are any from the audience.
I'm looking at to see if any questions have been typed in, and just type in the dashboard on the right-hand side where the questions are. Just you might have to hit the down arrow to type in your question. Let's give it a couple seconds if anybody has any questions.
Okay.
Well, let me just give my 2 cents about patent protection and trademarks. It's so important to have a good IP plan because we're a development company ourselves, and we have numerous trademarks and IP and patents to help protect ourselves. But it's also key on the takeaway points that you brought up. Make sure you have all the protections in-house, especially on the trade secret side, because that's such an important portion of it when employees leave and come and go. And all right, I got a question here, and so you suggested to send an NDA with some new samples that you might send to a vendor or somebody who might be doing production for you, or to even some customers out there. Does each new sample that you send out require a new NDA?
So if the samples are going to different third parties, then each sample would require an NDA. Does it need to be a different NDA for each third party? Well, it needs to be tailored to each party that you send it to. But the confidentiality provisions within the NDA may be the same.
Great. This is going to be a loaded question, but it's probably very difficult to answer. But how much do utility and design patents cost in the U.S. and then European or WTO related?
Claire, did you want to speak to that? The issue is there's the basic filing fees, but then depending on the complexity of the technology involved, and if you hire an attorney to handle the prosecution of your application, the cost could vary wildly, in my experience. So it's difficult to answer beyond sort of the basic filing fees that are required for a U.S. utility patent application.
Yeah, I agree with that. It's really highly fact dependent. One general trend that I have observed in drafting and preparing applications, however, is that the earlier that you get your attorney or the person that is going to assist with drafting the patent application in the process, the easier and typically the less expensive it can be, because the cost of prosecuting an application can be minimized by building as robust of an application as you can in the beginning, with the hope that that minimizes the obstacles that you encounter, right, in the different patent offices. And having your attorney be involved in understanding what that you're trying to protect, what kind of research has been done, what data is available, is key in drafting a good application. I have experienced both ends of this. I have dealt with clients that give me a paragraph and very close to a timeline for disclosure, very close to when it needs to go out, and the ability to draft a robust patent application in that short time frame with that limited information, it's difficult to do, right? So you may save up front in drafting that application, but what ends up happening is that then you end up encountering a number of issues as you start prosecuting. And that can add costs, right? Now, that's expense that doesn't happen right away, but happens a year, 2 years from filing, but that can amount to much more money than you expected to spend in prosecuting your patent. So just working with smaller companies, the earlier I know about the project that you're undertaking, that I can help you figure out what art have you looked at, what's out there, what is the state of the art, the better your patent application will be, and ideally that can minimize cost in the long term in prosecution. Understanding also what your goals are in terms of the business application can then help you decide and help your attorney advise you in whether it's worth going through filing a PCT or not, or whether you may want to enter a couple of different countries just with individual applications. All of those decisions will actually play a role in how much it costs to prosecute the application, but also whether those costs are paid up front or somewhat deferred through the desired route. So getting the proper people involved earlier in the process can result in just cost savings in the long term.
Yeah, I'd have to agree with that. I mean, so we have 3 patents ourselves in our company, and the first patent I ever filed, I went to my attorney and gave him a general overview of, I would like to patent X, and it cost me a lot because I had to go back and redraft and explain a lot of why I wanted to do it. And it really comes down to why you want the patent, why you think, and working with an attorney from the front end. I think going in later in the steps, it just cost rises. So as soon as you start designing and coming up with ideas, to engage an attorney just to share some ideas might be a good start. But can you talk about some of the basic filing fees that would be associated with a patent, maybe on the U.S. side?
Sure. I can just double check on those, but it typically might be below $3,000. The filing fees are not that high in the United States. The filing fees are, one of the strategies that is typically used for. Let me just double check. For a lot of particular smaller companies is to start with a provisional application and then convert that to a non-provisional, and that can defer the cost of the drafting. The basic filing fees it's even lower than I was thinking. The basic filing fees in the United States right now are $280 for a utility application, and then there are some excess fees that are applied when you have additional claims, and if it's filed in the United States but as a PCT, there's also additional fees for searching. And I would be happy to share, with the audience later, perhaps a couple of links where the fees can be readily found, as they can change from time to time.
And one thing I think may be particularly applicable here is the fees are lower if you are a small entity or an individual filing for a patent application. So it's good to look and see whether or not you fit any of that criteria, because the cost would be much less.
Mm-hmm.
So another question is, if I'm a small business and I want to partner with a larger company that's multiples of sizes above me, even with an NDA in place, is there anything I can do to ensure that they won't circumvent my IP or circumvent any kind of agreements or anything, how that can be structured out?
So, I think one thing you have to do is do some due diligence on the larger company to make sure that you're working with someone who's going to be straightforward and honest with you. So that would be my initial recommendation or advice. Secondly, if there are some concerns, you need to make sure that your non-disclosure agreement is very clear, that if the information that's exchanged under the agreement is misused or used outside the agreement, that that's not going to be proper. So I think at least those two things are something to keep in mind if you're not going to do the patent route where you file for a patent application before you start seeking to look for a partner to work with you to develop your technology.
So there's another question. Sorry,
mm-hmm.
Go ahead.
No, I was just going to follow up to that. It's also very important to understand that the timing of the non-disclosure is key. I have been involved in proceedings with interference proceedings where typically arise where two parties are claiming that they invented the same thing. And oftentimes the issue is that there wasn't a clear definition of who was contributing what to the project, and the NDA doesn't get signed until after they're beginning to collaborate together. An NDA typically should be signed before you disclose any critical information. If you've had extensive conversations and the NDA is only entering into as you are giving a prototype, in some instances it might be too late because the actual idea and the content and everything that was substantive before the prototype has already been disclosed. So both the timing of the NDA and the substance of it and how robust it is can help you, particularly with larger companies, make sure that your information and your IP is protected.
That's some great info there. One last question here, and I'm going to try to plug in some answer from my side too, but sometimes, as a business, it's a risk. You don't know what you'll earn from a potential IP filing. So attorney costs sometimes can be high. Do you suggest starting with an attorney off the get-go, or try filing it yourself and try to do it yourself? Let me just step in on my side. What I've done in the past, I've tried it myself in the past, and I was very unsuccessful, and it's a lot of headaches that you're going to be facing. There's a lot of nuances to patents that are out there, claims, and a lot of terminologies, and patents are only as strong as how you can be able to enforce it in the future. So you really want to make it as tight as possible, and attorneys who are in the industry and who understand the nuances can really assist you in kind of formulating strong claims and strong basis to your patent. So in the future, if you ever had to enforce it, it would work out a lot better.
I have to agree with your experience, and I think engaging an attorney probably sooner rather than later is the way to go, even if you're unsure whether or not what you're developing is going to be a success or not. I found in my litigation practice, I litigate in the chemical area, that sometimes when you're asserting a patent, it's a patent that you didn't even know was going to be the most important patent in the portfolio, but the way the market developed, it turned out to be. So it's important when you're in any situation to make sure you have the strongest patent as possible. And working with an attorney can help you perhaps identify ways to frame your patent so it can cover embodiments or variations of your technology that you hadn't even thought of before. So I think engaging with an attorney earlier rather than later is the way to go. Claire, do you have any thoughts on that?
No, I agree. I think that getting the view from an attorney, in addition to just the little issues that the nuances that go through a prosecution process, is exactly what Marisa talked about. We have seen, for the most part, somebody who has some litigation experience, we have seen what happens at the other end, right? We have seen what happens when there's a breakdown in the relationship or there's an infringement, and now we have put together that case for getting enforcement. So the value doesn't just come from knowing how to use the proper terminology and draft the document correctly, but it also comes from that more robust approach to protecting your IP and knowing the timing and understanding what various aspects should be protected. So in my experience working with the smaller clients particularly, I typically try to learn their business and know kind of where their R&D is going, what kind of projects they're working on. So when they do come to me with their next project, I have a sense of where the business is going. I have a sense of what the business is pursuing. And this kind of ties in a bit with your question in the pricing and the cost of the attorney. That that relationship may require exchanging some time and doing some work early on. But over time, the familiarity of the attorney that you're working with and your company and your technology is going to make the process more efficient when they're drafting new applications for you or prosecuting new applications for you. I have clients that have done work for many, many years, and I have gone from drafting their applications to when they do get involved in contentious situations with other parties. Just by drafting and working with them, I'm so familiar with their technology that some of the fees that are associated with handling those more complex procedures can be lower a bit because the background is there, the understanding is there. So again, human relationship, there is a value from working with somebody who has the legal knowledge but also can get to know and understand your business.
Thanks for all that information. And I wanted to conclude the webinar for today and appreciate Marisa and Clara to take the time out today and give us some great information. And I think you guys are coming out to the ATP conference too, and also IFAI Expo, and going to be presenting some more information there. Is that right?
Yes, we look forward to seeing you. We will be talking a bit more in detail about the value of design patents and in this industry, and we'll definitely be around for the conference, so feel free to reach out to us and let us know if you're going to be there. We'll be happy to chat more with you.
And that's where the IFAI Expo is a great venue for not only for business development, for just a knowledge resource about learning on new concept, new ideas, and also how to protect yourself in the future when you're coming up with those new ideas. So I just want to mention the IFAI Expo coming up in September from the 26th to the 29th in New Orleans, and we'll have an AT conference going on as well that will feature educational tracks in medical, military, smart fabrics, and testing. And if you have a topic, and we want to do more of these webinars in the future, so if you have any topics that you would like to have us cover at all, or even expand on a subject that was within this webinar, please contact the ATP. You can contact Janelle Wells, listed on the slide here. You can see her email address there. My email address is there as well. I love to have conversations over a good beer. I'll be in New Orleans, so at the IFAI Expo, if you ever want my experience on patents or trademarks, you can always email me and connect up with me. I'll be there all week. And John Curry is a great resource. He's our division supervisor. He's a great person to reach out to. And thanks again, everybody. Clara and Marisa from Finnegan, thank you all for attending, and look forward to the next webinar.
Thank you.
Thank you.